So I want to thank you all for joining us this afternoon. My name is Kenyora Parham. I am the Executive Director of NRAPE on campus, and I'm joined by my colleagues and partners in this work, Tracy Vichers, Executive Director of It's On Us, and our special guest, Valerie Jarrett, former Senior Advisor to President Obama and former Chair of the White House Council for Women and Girls. Thank you, Valerie, so much for joining us and sharing your thoughts on Title IX. We also want to thank you all for joining our virtual town hall on Title IX, where we recognize that we are gathered together under not so great of a circumstance. Especially with the COVID-19 pandemic underway, we recognize that social distancing and being in quarantine has been tough on many, and we hope that you all are getting what you need to take care of your emotional, mental, and physical health. As you may have seen in the past 24 to 48 hours, Secretary of Education Betsy DeVos decided to release the Title IX regulations during the COVID-19 pandemic. The Title IX regulations is a over 2,000-page legally binding document that alters the way schools handle sexual misconduct reports and proceedings. This includes investigations, hearings, and informal resolutions. Schools across the nation will have to comply with the new rules by August 14th, upon which they will go into effect. The problem with these rules, including releasing them during a global public health crisis, is that they strike back survivors' rights, especially for those who have currently open Title IX cases, and places an unfair burden on school administrators. So to give you a rundown of what to expect during this town hall, first we'll hear from Ms. Jarrett and her thoughts on the new rules. Then Tracy will provide you with an overview of Title IX and dive deeper into what these regulations mean for survivors and campus administrators. And I will provide you with a rundown on what we have coming down the pipeline with regards to our calls to action. We will also close out this town hall on a positive and inspiring note from a phenomenal woman of our community, Cheyenne Tyler Jacobs. Now, before I introduce Valerie, I want to say to everyone on this call that you are not alone. And we completely understand that this decision may be triggering for you. And at any point throughout this call, in this town hall meeting, if you feel that you need to step away, please do not hesitate to do so. If anyone or someone you know needs immediate support, know that hotlines are still open during COVID, and you can call RAIN at 1-800-656-4673. Additionally, we understand that some of you may want to share your story throughout the chat room. And if you do so, we actually ask that you share your stories directly with us, the hosts of this call, after the call. You can even send us your story at info@nrapeoncampus.org. The point of the call is to share information on the Title IX regulations, and we ask that you just join us to take further action against DeVos. We don't want to cause anyone to be triggered by another and further perpetuating harm. As we know, DeVos has already done that enough as it is. So thank you for your presence and thank you for being here. Now, to continue with our program, I'd like to introduce to you our guest speaker. Valerie B. Jarrett is a Senior Distinguished Fellow at the University of Chicago Law School and a Senior Advisor to the Obama Foundation and attorney. She serves as the chairman of the board of When We All Vote and co-chair of the United States of Women. She also serves on the board of Ariel Investments, 2U, Lyft, the Innocent Project, the Economic Club of Chicago, and the John F. Kennedy Center for Performing Arts. Her New York Times bestselling memoir, Finding My Voice, My Journey to the West Wing and the Path Forward, a great read, I might add, was published in 2019. Ms. Jarrett was the longest serving senior advisor to President Barack Obama, and she oversaw the offices of public engagement and intergovernmental affairs and chaired the White House Council on Women and Girls. Ms. Jarrett worked throughout her tenure at the White House to mobilize elected officials, business and community leaders, and diverse groups of advocates. She led the Obama administration's efforts to expand and strengthen access to the middle class and boost American businesses in our economy. She championed the creation of equality and opportunity for all Americans, economically and politically empowering women in the United States and around the world. She oversaw the administration's advocacy for workplace policies that empower working families, including equal pay, raising the minimum wage, paid leave, paid sick days, workplace flexibility, and affordable childcare, and led the campaigns to reform our criminal justice system, end sexual violence, and reduce gun violence. Ms. Jarrett has a background in both public and private sectors, and she served as the Chief Executive Officer of the Habitat Company in Chicago, Chairman of the Chicago Transit Board, Commissioner of Planning and Development, Deputy Chief of Staff for Chicago, Mayor Richard M. Daley, and she also served as the Director of numerous corporate and non-for-profit boards, including Chairman and Chief Executive Officer of Chicago Stock Exchange, Chairman of the University of Chicago Medical Center Board of Trustees, and Director of the Federal Reserve Bank of Chicago. Ms. Jarrett practiced law for 10 years in both the private and public sectors and has also received numerous awards and honorary degrees, including Time's 100 Most Influential People, as well as the Abner J. Mikva Legal Legends Award. Jarrett received her BA from Stanford University in 1978 and her JD from the University of Michigan Law School in 1981. Please help me welcome Ms. Jarrett.
Oh my goodness. Thank you so much, Kenyora, for your leadership, for that amazing introduction, for everything you do each and every day on behalf of those who need you the most. This is a tough day, and it's why I wanted to come on. I invited myself on this call because it was important to me, as you said, for those who are out there to know that you are not alone. As we're going through this challenging time, I know that you and your families are grappling with the health, the economic, and the educational challenges of the COVID-19 pandemic. And I also know that because many of you are activists on our college campuses and communities and are committed to ending sexual violence, your challenges grew even greater as a result of the recent action taken by the Department of Education. Long before there was a COVID-19 pandemic, there was an epidemic of sexual harassment and violence on our college and university campuses. In light of the epidemic, and since Title IX is a civil rights statute designed to give students equal access to education, during the Obama-Biden administration, our Department of Education challenged itself to do more to end this epidemic and to protect survivors. So after a process of listening to a broad range of stakeholders, including the brave voices of survivors, fellow students, parents, administrators, researchers, rape crisis centers, local police, healthcare providers, and many, many more, we issued the original guidance because we wanted to make sure that schools understood that as recipients of federal dollars, they have a responsibility to ensure that sexual violence would not be tolerated and that they took their responsibility to protect survivors seriously. The final rule that was just released by the Department of Education strips away many of those protections, and it is particularly egregious given that they issued, as you said, 2,000 pages of regulations in the midst of this pandemic and now expect schools to be ready by August with everything else that we have on our plates, trying to figure out how to revamp how we educate our students online, dealing with tuition and reimbursements, the administrative nightmare that this COVID-19 pandemic has presented has now been exacerbated by the voluntary actions of the Department of Education. Now, I know you're going to be hearing from the amazing Tracy and more from Kenyora about the implications of this rule and how we could organize, but I wanted those who are committed to ending this epidemic and those who have suffered as a result of it to know that you are not alone. We launched It's On Us during the Obama administration with the help of many of you on this phone call right now, knowing that the true power of change rests with all of us. That's why we call it It's On Us. And we cannot let this outrageous action taken by the Trump administration lessen our determination to end this epidemic and protect survivors. We will not, and it is still on all of us. Are the challenges greater now than before? You bet you. Are we up to that challenge? Absolutely. So I just wanted to come on the top. I know it's going to be a great call. I wish I could stay for the whole thing, but I was just determined to come on and just tell you one more time, you're not alone. We stand with you, and we are ready for a fight. Thanks so much, everyone.
Thank you so much,
You're
Ms. Jarrett.
welcome.
We
You're
appreciate
welcome.
you coming on today and for all of your leadership and work.
Thank you. Take care, everybody.
Thank you.
Bye-bye now.
Again, thank you so much, Ms. Jarrett, for your remarks today. I'm so grateful she was able to come on to share her thoughts with us. And thank you so much, Kenyora, for helping to kick off this virtual town hall. Thank you also to everyone who has joined today. I know Kenyora said this earlier, but I really hope all of you are staying safe and healthy during this very uncertain time. For those of you who I have not yet met on this call, I am Tracy Vichers, the Executive Director of It's On Us. To put it bluntly, the decision by Secretary DeVos to release her dangerous rule changes to Title IX during a global pandemic is cruel. Survivors and students across the nation have had their academic year disrupted by COVID-19 and are struggling to adjust to a range of uncertainties and unprecedented challenges. As Ms. Jarrett also said, it is also exacerbating the challenges schools are currently facing due to COVID-19. That the Department of Education is requiring schools to come into compliance with the Title IX rule changes by August 14th of this year. Schools across the country are rightfully focused on determining how they can safely reopen next fall and do not need the unnecessary additional burden of implementing new and harmful Title IX rules that, frankly, the vast majority of them have taken issue with since they were put forward for public comment in 2018. For those of you who are not as aware of Title IX, I'm going to talk a little bit about that and its history, sort of how we got here. And then I'm going to dive further into some of the larger pieces of the rule change and the implications that they will have for students come this fall, unless we and some of our partners in the field are able to stop that from happening, which Kenyora will talk about a little bit near the bottom of the call. But to get started, for background, Title IX is a federal civil rights law that requires any K-12 school or institution of higher education that receives federal funding to uphold gender equity in their policies and practices. Since the days of the Clinton administration, Title IX has been interpreted to provide protections for students experiencing sexual violence. During the Obama-Biden administration, guidance was issued by the Department of Education in 2011 and 2014, clarifying for colleges and universities their responsibilities under Title IX to prevent and respond to incidents of campus sexual violence. The guidance strengthened student and survivor rights and worked to enhance campus safety. Unfortunately, in 2017, Secretary DeVos rescinded this guidance and in November 2018 put forward her proposed rule changes to Title IX for public comment. More than 124,000 people submitted comments on her proposed rule changes, with the vast majority opposing the dangerous proposals. Sadly, as we all know, and why we're on this call, this week, she made the decision to move forward with issuing them. I will now walk through some of the key rule changes to Title IX that were issued this week and what they mean practically for survivors, students, and administrators. As Kenyora noted, the entire document published by the Department of Education is more than 2,000 pages long. And so we are continuing to sift through it, but we wanted to have this call to be able to share some of the top lines with you. And that's why for the purpose of this call, we will focus solely on the major rule changes. I also want to call out that throughout the 2,000 plus pages put forward by the Department of Education, there is victim blaming language, deeply misogynistic language, and the perpetuation of dangerous rape myths as justification for why these rules have been put forward. I want to acknowledge that many of these rules are grounded in sexism and the myth that survivors lie or exaggerate their claims. I also want to call out that while these rule changes are devastating to all students and survivors, it will be students of color, LGBTQ students, students with disabilities, and other historically marginalized student populations who will face even higher barriers to support and justice because of systemic oppressions within higher education that already exist, coupled with these rule changes. I want to also say that if at any point you feel overwhelmed or triggered throughout the review of these key rule changes, please do not hesitate to take a break from this call. As we mentioned, we are recording it and we will be sharing it with attendees following the conclusion of the call. I also want to flag that after I run through the rule changes, we do have some time set aside to answer any questions that you might have about them. Please drop those questions into the chat function and we will do our best to answer as many of them before we have to conclude our program today. First and foremost, as we dive into these rule changes, I want to provide a quick definition. So as we talk through it, everybody on the call is able to understand that in the new rules, the term sexual harassment is deemed to be inclusive of acts of sexual assault, dating violence, domestic violence, and stalking. So if the term sexual harassment is used, please note that it is inclusive of all of those acts. And so we will actually start with that definition as we talk through the rule changes. So one of the really key rule changes put forward by the Department of Education is that under Title IX, it now narrows the definition of sexual harassment to unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person access to their school's education program or activity, and adds that the conduct could be considered harassment if a quote-unquote reasonable person would say it was. And it simultaneously mandates that schools dismiss complaints that do not meet the sexual harassment definition, even if the allegations are proven to be true. This definition is deeply problematic for many reasons, particularly that a student would likely have to experience escalating and ongoing violence before their school would be required to take action to stop and investigate it. It also leaves the severity open to interpretation by administrations who might have a vested interest in not wanting to pursue action against an alleged perpetrator, such as a high-profile student athlete or other high-profile member of the campus community. The rule also makes schools responsible for investigating only incidents of sexual assault or harassment said to have occurred within their programs and activities. So for example, if a sexual assault occurs between students at an off-campus bar, the school is no longer responsible for taking action. And we know that approximately 85% of students today live off campus. So this would also apply to incidents that occur between students in, say, off-campus apartments or other housing. Additionally, the rule limits that the complaints that schools are obligated to investigate are only those filed through a formal process and brought to the attention of officials with the authority to take corrective action. What this means practically is that if a student fails to report to the right individual or through the right channels, their school is not responsible for taking any action. In the case that a survivor's assault does somehow meet these very high thresholds and are put through all of the right channels to be investigated, colleges now also have new requirements for how the investigation and adjudication processes must be implemented, including new requirements for how schools interact with accused students. For example, under the new rules, colleges will be required to hold live hearings during which both parties can be cross-examined to challenge their credibility by an advisor of their choice. The advisor does not have to be a lawyer, and based off of the interpretation of the rules, there doesn't seem to be any limitations specified as to who that advisor can be. This means a survivor may be required to undergo cross-examination by their perpetrator's parent, coach, fraternity brother, or other individual who has a vested interest. The live hearing model also, even if it's facilitated through technology such as Skype, which is permitted by the rule, alone could prevent a survivor from pursuing action against their perpetrator and re-traumatize the survivor if they do pursue action. As part of the cross-examination, questions about a survivor's prior sexual behavior is thankfully barred with two exceptions. One, a party's medical or psychological record can only be used with that party's voluntary consent. And recipients are instructed that only relevant questions must be answered, and decision makers must determine relevance prior to a party or witness answering a cross-examination question. Furthermore, schools will be prohibited from retaliating against a student who may have been engaging in other forms of misconduct at the time of their assault, for example, underage drinking. Furthermore, the rules permit schools to choose which evidentiary standard to use to find students responsible for sexual harassment or misconduct, either the preponderance of evidence standard or the clear and convincing evidentiary standard. The preponderance of evidence standard essentially means that the burden of proof is met when the party with the burden, e.g. the survivor in this case, convinces the fact finder, such as the school's disciplinary or hearing board, that there is a greater than 50% chance that their allegation is true. In contrast, in the case of clear and convincing, to meet this threshold, the evidence must be highly and substantially more likely to be true than untrue. Therefore, the fact finder or hearing board must be convinced that the contention is highly probable. For reference, historically, schools have been required to use the preponderance of evidence standard for all investigations into student misconduct, ranging from sexual violence to underage drinking to drug use. And in cases of sexual misconduct investigations, it has been the evidence-based standard because of the realities that accompany incidents of sexual violence, such as, for example, a lack of eyewitnesses or limited physical evidence. It is deeply problematic that schools would be permitted to apply one evidentiary standard to sexual misconduct and a different standard to all other student misconduct violations for many reasons, with a key one being that it signals that students who are reporting sexual violence are therefore less likely to be trusted, and therefore their claims must meet a higher evidentiary threshold than other forms of student misconduct that are reported. This is deeply victim blaming, and frankly, so problematic. Also deeply concerning to us about the rule changes is that schools are not required to adopt a particular or uniform definition of consent with respect to sexual assault. This will allow schools to essentially choose their own definition of consent based off of a hodgepodge of state and federal definitions. In the best case scenario, schools will adopt explicit affirmative consent definitions, but in the worst, they may ultimately end up vague and difficult to enforce. Furthermore, under the new rule change, schools will be permitted to use mediation to resolve sexual harassment violations. This is deeply problematic in that it has the potential to feel as if the violence a student experienced is being minimized, and that survivors may feel pressured to accept less justice than they deserve. In addition to these new requirements around the investigation and adjudication process, schools will also have additional restrictions and requirements focused on accused students. For example, it will mandate that Title IX coordinators provide quote-unquote supportive measures to accused students, and require schools to give accused students written assurance that they are presumed innocent unless otherwise found culpable through a formal investigative and adjudicative process. And schools will not be able to take any form of disciplinary action against an accused student until the end of the case. The one good piece is that they do have the right to remove an accused student from campus if they are considered to be an ongoing threat to campus safety, but ultimately the school will determine that. And so there may end up being a student who remains on campus who is a threat to campus safety, but the school has just deemed that they are not for whatever reason that they have decided. These changes are problematic because they imply that a student who has filed the sexual assault allegation is lying or exaggerating, and therefore the accused student is the one who must be protected, rather than the survivor who has potentially, rather than the survivor who has experienced harm. One of the final pieces that we want to talk about is also that the Department of Education will only find schools legally culpable for mishandling allegations if they are proven to have been deliberately indifferent in carrying out mandates to provide support to victims and investigate complaints fairly. This is a vague standard to hold schools accountable to that will make it difficult for survivors who have been harmed by their school's process to obtain justice. So I know that that was a ton of information, and that some of you may be feeling really overwhelmed. And I want to know that we will be pushing information out over our social media and email lists from our own work, from our partners' work, to make sure that everybody has the best information possible about what's going on with the rule changes. So we were tracking a bunch of questions throughout the throughout the description of what's going on. So I will go through some of them, and we will continue to go through all of them. Kenura, also feel free as we're going through this to also weigh in on these answers. So we are going, I'm just going to take a look at these pretty quickly and just see. So one of the questions that we've received is, how would we recommend student leaders take action on our campuses? So Kenura is going to talk a little bit more about what actions are going to be taken by ourselves and other partners in the field, as well as what students can be doing after we finish this portion. So Kenura will be able to answer that. And then let me see, what else do we have in here? Also, a similar question, what can we all do to get more involved in stopping this rule from taking effect? Yes, Kenura will also be talking about that. So we will continue to do that. So there are some specifics in here around, can schools choose to not include cross-examination in their process? From the interpretation of the rules that we and other partners in the field have seen, it is a requirement that schools allow it to occur. For example, there may be a situation in which students do not, in which both parties do not choose to pursue that, but I do not believe that schools can just choose to not include cross-examination in their process. Clarity. Okay, so somebody asked, I read somewhere that incidents that don't meet their threshold or didn't happen on campus can still be investigated as student conduct violations. Can someone provide clarity on this? So again, there are going to have to be pretty, as we talked about earlier, the definition is going to be very, very high. Students will still have options to report to law enforcement, although we understand that that is often not always the safest option for students. Students can continue to still seek support services from their schools, but our interpretation of these rule changes is that the schools will not be responsible for investigating incidents that do not meet the definition or do not fall within the purview of these rules. Second additional question, what was the underage drinking point again? So underneath the Title IX rule changes, essentially it states that schools cannot retaliate against students who are involved in a sexual misconduct investigation because they were also engaging in other forms of student misconduct at the time. So if a student experiences sexual assault and they had also been underage drinking at the time of the assault, the school can't take action against them for the underage drinking. So that's essentially what that means. Something else that was flagged was asking more about the off-campus piece. So essentially the rule states that schools are not responsible for investigating incidents of sexual harassment or misconduct, even if they occur between two students, if it doesn't occur in a school-sanctioned activity. So there had been a lot of back and forth for folks who have been following the Title IX conversation since the proposed rules came out in 2018 about what is a school-sanctioned activity. Particularly back in 2018, there were concerns about incidents of sexual assault that took place, say, in fraternity houses. The fraternity itself is a school-sanctioned activity, but the idea that somehow the school wouldn't have the ability to take action over that came up quite a bit because it wasn't considered on campus necessarily. The rules do qualify, the rules that were put forward this week do qualify in them that if the fraternity, for example, is officially recognized by the school is responsible for taking action if an incident occurs in that fraternity house, regardless of if that building is considered on or off campus physically. However, we do know that there are a lot of student organizations that aren't actually recognized by a school, and so including some fraternities and sororities. So in those cases, schools, if they don't recognize them as a school sanctioned activity or program, would not have to take action. We also know that in some cases, right, you have groups of students, such as like student athletes from a particular team, they all might be on the same team and live in a house together, and students on campus may think of it as the lacrosse house or the ice hockey house or the soccer house or the baseball house. However, it's not technically on campus. And even though all of those students are also all on the same team, the activities that they're participating in that house are not considered school sanctioned activities. So again, in those instances, the school would still not be responsible for taking action. So it creates this very confusing situation for students to know exactly what is a school sanctioned activity or not know what a school sanctioned activity is. And so that's really problematic, because from our perspective, if an incident of sexual violence takes place between two students, the school should, regardless of where that it physically happens, that the school should be responsible for offering protection to the survivor and for investigating the incident that occurred.
Yeah, I'll jump in here too and say that for those who are asking about the like studying abroad, as far as we've been able to see, the regulations are only requiring incidences that take place in the United States, and unfortunately not in international waters, out of fear for being involved in a conflict that is unintentional, and conflicting with laws of different countries. And so even though it might be an educational program and activity that a school is hosting in terms of the study abroad program, essentially, because you're in a different country, you would have to adhere to the rules of the country laid out of the country that you're attending. But essentially, the Title IX rules do not carry over to that country that you may be studying from. So even though, like Tracy pinpointed about, regardless of the place and where things take place off campus or on campus, I also wanted to note about the studying abroad piece for those who may have that question.
Thank you, Kenyora. Absolutely. Great. So one of the pieces that I do want to address, because it keeps coming up in the chat, is we have been asked repeatedly about the allegations against Vice President Biden. It is a fact that It's On Us was born from the Obama-Biden administration, and Vice President Biden has been a key ally in this initiative over the years. And we have been grateful for his ongoing support of our work. However, It's On Us is a 501c3 nonprofit program of Civic Nation, and our status therefore limits our ability as an organization to comment publicly on any actions taken or allegations made against political candidates for office. This would also apply to President Trump's allegations. That said, we do believe that all individuals coming forward to share their stories have a right to be heard and to have their allegations investigated. So I just wanted to put that out there because it keeps coming up, and I want to make sure that we are spending our time right now talking about the Title IX rule changes. So hopefully that helps folks understand where our position is on that at this time. Additional questions?
And I can also answer a question about did you already do the formal process regarding reporting directly to the Title IX coordinator to put the university on notice? Did we do that one?
No.
Okay. So essentially, from what I understand and what I've been able to gather is that if the Title IX regulations go into effect on August 14th, essentially, there may be a retroactive that may occur in which once you inform the Title IX coordinator of a sexual assault, they are put on notice. And that person is the only person in which you can formally report to in order for the school to take action. So if you do report to anyone outside of who's not Title IX coordinator, whether it's your professor, a coach, or your residential advisor, essentially they will not deem it as having the university be put on notice, which is unfortunate. So like in the K through 12 schools, it applies, like students there can talk to anyone, but in terms of higher education, you specifically have to go to your Title IX coordinator in order for the school to be officially put on notice and have acknowledgement of what's happening, what's going on.
We have so many questions. I'm trying to make sure that I'm grouping them together because there are some that are very similar to one another. So there were additional questions about the live hearings. So live hearings are now a requirement that students will have to participate in them. It's not just something that schools can just offer. It is now a mandated part of the process that students will have to participate in. There was also sort of an additional question to that of who gets to choose the advisor. The advisor is of the student's choice. So as we mentioned earlier, the person advising a student might be a lawyer in some cases. It also might be a parent, it might be a coach, it might be a faculty advisor. There doesn't seem to be any kind of specification in the rules or limitations in the rules of who that person could be. So just wanted to flag that because that has been coming up quite a bit. And again, our concern about that is really a cross-examination alone or a live hearing threat alone may dissuade survivors from continuing to pursue an investigation into their sexual assault. Because even if it is facilitated via technology, which the rule does allow for, so such as Skype, Google Hangout, et cetera, where the two students are in separate rooms, but it's happening live via technology, that is still a massively emotional undertaking for a survivor to have to sit in a room or via technology with the person who has assaulted them and have to face cross-examination and questions of the credibility of their claims from somebody who is there to represent their perpetrator. And this is essentially creating a situation where things such as student misconduct hearings are being turned into basically kangaroo courts. And that's deeply problematic. And again, a lot of these decisions and these regulations that are being put out in the rules are very much stacking it against survivors because the way that a lot of the decisions are as to whether or not portions of what were the proposed rule changes in 2018, much of the discussion of whether or not changes were made in the 2,000 plus page document, if you were to read through them, they are deeply steeped in misogyny and myths that survivors lie or exaggerate their claims when they come forward, when we know that that's not true. We know that less than 10% of survivors on college campuses report at all. And so that and when they do report, it is like they need to be believed, they need to be supportive, and they need to have a trauma-informed process. And so the fact that this is a very trauma not informed process is deeply problematic. And so, I cannot imagine having to sit in a room or via Skype and be cross-examined by somebody who has a vested interest in harming my credibility through that process. And so just want to flag that is just so horrible and deeply just so unreasonable to ask a survivor to go through that, particularly when this hearing model is not being applied to any other form of student misconduct that a school would be otherwise required to investigate. This wouldn't be the process for underage drinking. This wouldn't be the process for other forms of assault that happen on campus or burglary. It is solely being applied to sexual assault allegations because, again, these rule changes are being put forward from a place of very deep misogyny and rape myth. So just wanted to flag that. Other ones that we're seeing, Kanyora?
Yeah, I think there was also a question with regard to do these regulations impact or change colleges that are required to report under the Clery Act? Un- Unfortunately, let's see. What I know is that, like earlier today, we were actually on a call with members of Congress who actually urge and reauthorize and support the bipartisan Campus Accountability and Safety Act as part of the Higher Education Act of 1965. This particular act is something that will help to essentially check the Title IX regulations and provide those checks and balances in terms of offering that transparency requirement that schools are supposed to make under the Clery Act, to make sure that everyone has an understanding of what's happening on colleges and university campuses, especially for high school students and their parents when they're trying to make informed decisions on where to go to for schools. The schools are supposed to have that information up on their website so that way they can make those informed decisions. So Clery Act is there, schools are supposed to adhere to it. However, from what we've been seeing is that there's not a true enforcement of the penalties. And so we're trying to really utilize the Campus Safety Act and Higher Education Act to really push forward the Title IX as another way to provide that buffer and that sense of transparency.
Great. Another question that came up was regarding the letter given to the accused students, indicating that they are deemed innocent until proven guilty, for lack of a better phrase. There was a question that do accusers or survivors get any similar treatment, any letter or statement showing support for them? That is not required by the regulations. So again, very clearly the rules that have been put forward are being done so in a way that essentially bolsters it's deeply problematic. So just wanted to flag that as a question that came up, and it's really bolstering rape myths in that way. So wanted to flag that. It was one of the questions that came through.
Hey, this is Sylvia. Thought I'd help out since there are so many questions.
Thank you, Sylvia.
Like 200 unread. Hi, I'm Sylvia with It's On Us. One of the questions was if this will apply retroactively to active cases. Legally, it should not. So we'll see how that plays out, but I can tell you that legally it's not supposed to for anyone who has an ongoing case as of right now.
Also, there's a question with regard to online harassment. I believe this applies to that as well. Title IX applies to this.
It does. It also applies, thankfully, and this was actually not in the proposed rules that we got, 2 years ago. It does apply to all crimes covered in the Violence Against Women Act: sexual assault, sexual, domestic violence, dating violence, and stalking.
Mm-hmm. And just note that we may not be able to get to every question, only because this is over 2,000 page document. We do want to reiterate that. And the language can sometimes be a little confusing even for us. And we are working very diligently with partners at Know Your 9 and National Women's Law Center to make sure that the language that we are providing you is indeed correct, especially from the lens of attorneys, because we are not lawyers. But we are presenting you this information, to the best of our ability, and with the language in which we have to, I guess, bring it down to our levels of understanding.
A question that popped up was, do these claims apply to private universities as well? Or do these changes apply to private universities as well? Yes. So essentially, the way that the rules are written and Title IX is applied is that if a school participates in federal financial aid or receives federal funding, they are required to adhere to Title IX. One of the pieces that is in the Title IX rule change that we didn't talk fully about at this point in time, but is something to flag, is that there is now a religious exemption rule within the Title IX regulations, where schools can basically say that because of religious belief, they are exempt from upholding some of the rules and practices around Title IX and gender equity. We're still, it's on us and EROC, we're still sorting through exactly how that means and what that means, and how that would practically be applied. But schools will also not have to tell students that they have taken that religious exemption as it relates to Title IX, which is also deeply problematic. So if you go to a school that has some kind of religious affiliation and that pops up, it's going to be a problem. So just wanted to flag that is the case. And so I know that we only have 10 minutes left. We still have some additional content that we want to cover with you all, but thank you so much for all of your questions. We've been documenting all of them, so we will do our best to sort through all of them. There have been over 100 submitted, so I'm sorry that we couldn't get to all of them during this brief time that we have together. But as we shared, we will try to answer as many of them as we can, share those answers out, continue to provide resources to all of you that either we are creating or our amazing partners in the field like Know Your Nine and National Women's Law Center are creating. So please keep an eye out to all of our organization's social channels, email lists, to be able to stay updated. And Kenyora, I will turn it back over to you.
Absolutely. Thank you. And I just, again, want to reiterate, thank you for these questions. They're very important questions for us. And it allows us to get to understand and know what it is that you're thinking, what you're considering as we stand in this fight with you all. So even though Valerie and Ms. Jarrett is not on the call, I definitely want to thank her and thank Tracy for their expertise, their words of wisdom, and their time today. And especially Tracy, for you providing us with an overview of these dangerous regulations. As Tracy mentioned earlier, August 14th is the deadline for the Title IX rule to go into effect, which is really around the corner. So if anything, we need to just stop this from happening altogether and make sure that this Title IX rule does not come into law. So some of the actions that I'm about to share with you are facilitated by other partners in this work, and we want to make sure that their work is also highlighted, so that way the Department of Education understands that they have an entire coalition of sexual violence prevention advocates to get through. So before I do that, I just want to get a feel for those in the room on just some of the things that we're considering doing in the incoming weeks. And so just a show of yes or no in the chat box of how many of you would be interested in participating in a National Day of Advocacy. You could just say yes or no. Oh, we're going to turn the chat box right back on. Thank you. Absolutely great. That's what I figured. Awesome. Okay. And it just goes to show you that we're all thinking that something needs to be done. And of course we know something needs to be done, but it's reaffirming to know that we're all on the same page. So because we understand the power of the voice, we're working on a way to build a campaign that illustrates the personal narratives of student survivors and how this will impact students from across the nation. So stay tuned for more on our social media, on our emails. You can reach out to us if you're not on our mailing lists, you can sign up, which we'll provide for you in the next email that we send out, as well as in this chat box if it's somehow able to be seen, because I know there's a lot going on there. But I also want to let you know that we're also collaborating with Platform, a political training and lobbying organization dedicated to ensuring the voices of all who identify as young women, non-conforming, non-binary, and femfolk are heard in the rooms where decisions are made. So we'll be co-hosting a listening session during their Our Voice 2020 listening tour. It's a bipartisan event in which we'll be engaging students between 18 to 28 years old to amplify their voices and their political power. And of course, that means student survivors. So this will happen on June 10th from 4 to 5:30. More information will be provided for those who are student survivors and advocates. If you wish to share your experience and why your survivors' rights matter during this 2020 election, please email me at info@nrapeoncampus.org. We will be sure to provide you with that information. Additionally, again, as I mentioned before, because these regulations are over 2,000 pages long, there's still a lot of work that we need to uncover and still a lot of work that needs to be done, a lot of fine-tuning that needs to be understood on our part. So therefore, we want to uplift the current FAQs that have been made possible by our partners and Know Your Nine. We'll be sharing their resources along with you. I know some folks from Know Your Nine are on this call as well and have been sharing their resources in the chat as well. So please feel free to utilize those resources. For any educators on this call, we're also urging you to stand in solidarity with survivors to take a stand on the rule changes. For example, you can ask your school to commit to using the preponderance of evidence burden of proof instead of the clear and convincing standard of evidence. We'll be sure to provide folks with some language, helpful language on what they can utilize within the upcoming weeks. And so that's just a couple of actions that we're taking and a couple of things that we're uplifting, again, from our partners of Know Your Nine and National Women's Law Center. But before we end this call, we definitely want to take this time to end this town hall on a positive and uplifting note. I want to welcome the beloved Cheyenne Taylor Jacobs. She is the founder and curator of the She Will Speak series. She's also the founder of her very own podcast called As I Was Saying, and she is a member of the NRAPE on Campus Speakers Bureau. So she will share with you a beautiful, uplifting, poetic piece from her collection. Cheyenne, I'll give it to you.
Hi, everyone. Thank you so much for joining this call. I know I saw some people like, can Sylvia and Cheyenne speak? And I'm like, oh, no. I'm towards the end. Like this is my part right here. But I definitely want to say before I start that although this is an inspirational piece, I want everyone to know they're valid and how they feel and that this work is important and it's hard, especially being a Black woman with what's happening with Ahmaud and Betsy and sexual violence and COVID. It's just kind of like yesterday I was laying there like, can I catch a break? Like, this is like a lot to take in. So I definitely want everyone to know that although this piece is inspirational, I don't want it to take away from the feelings sometimes that it's just a lot. But for me, my poetry really helps to help me know that even in the midst of when it's chaos, you know, your voice is needed. And I do believe that everyone on this call, you're here because you want to make a change, which means that despite, you know, everything that's going on, you're trying to equip yourself with the resources to do what you have to do to make sure that, you know, these regulations don't hurt anyone. And that within itself is inspirational. So I just wanted to give the priest like that. So it's not like, well, this is a very inspirational piece despite this. So like, thank you, Kenyor. My name is Cheyenne Taylor Jacobs. She Will Speak, like if you Google that, you'll find me. So this piece I actually wrote for MLK Day about 3 years ago, and I want to share it with you all today. So I read once that airports have seen more sincere kisses than wedding halls and hospitals. You know, they've heard more honest prayers than churches. So that makes me wonder, how many moments did you allow to pass by before you realize the simple breath of air that you are breathing, well, that makes you blessed? You see, I wonder Did you tell those you love that you love them today? Did you hug them today? Did you call or text them to let them know they crossed your mind on today? Or are we all under this false notion that we're going to get that chance tomorrow? You see, my love, even the Bible says tomorrow is not promised. But please don't be confused, because I truly think time is perfect. You see, time. You see, we as people, we have put limits on our time. We created these milestone celebrations, and when we fall short, we say that we are broken. We say that we have failed. My brother, my sister, even a broken clock, although not ticking, its numbers hang, illustrating the infinite possibilities of timing. And since we are now speaking about illustrations, you know, even broken crayons can still colored, which means to me it could be both broken and a blessing at the same time. You see, time. I wonder when we'll take a step back to try to heal the wounds we like to cover up with clothing. You see, too many of us have been surviving since the day we exited the womb, bound to these generational curses, asking why these children's storybooks do not seem to truly reflect the toxic family structures we stem from, but we don't have the time to think about that, right? Time. You see, I wonder why I had to be born in the generation that hates catching feelings. Like, we are so afraid to actually find love. You see, I wonder if before we tried to love someone, someone first told us we were created in the image of love. I wonder what would happen if they told her our thoughts were precious and we were beautiful and we were in fact special. You see, I wonder, have you ever taken a moment to realize you really are special? And I know what someone's going to say, and you're right. But not everybody can win first place. But if we judge a fish on how well it can climb a tree, it's going to live its whole life thinking it is stupid. You see, I wonder, have you ever realized that you're not stupid? You see, I wonder, have you ever taken a step back to think about the words you say? And sometimes not always what you say, it's what you didn't say. It's how you make people feel. I wonder, have you ever taken a step back and wonder how you make people feel? And all the reactions on how we react to how people make us feel is done between the ages of 0 and 5. I wonder if you just caught what I just said. That means the most important lessons in your life, you don't even recall learning. You see, I wonder if our government realized if we help the people more than hurt the people, crime might actually go down. You see, I wonder, did you know that for every bad piece of news you see on TV, there are 4 pieces of good news that you'll never hear about? And I wonder what would happen if we heard about those people. You see, I wonder when Black lives will matter. I wonder when we can love who we love. I wonder when our bodies will be ours. And I said it because I was made to cut boundaries. You see, my tongue was not made to cater to the insecure. You see, I wonder if you realized you were not created to cater to the insecure. You see, I wonder, did you realize we are still trying to grow in poison soil? You see, my love. I wonder if we realize community is our answer. I wonder if we loved each other. I wonder if we support each other. I wonder if we realize we still have time to make this all right. You see, I've never seen the sun ask the sky permission to be seen. It just does. So like the sun, they have 2 choices. They can either bask in your light or they can wear shades. However, neither choice should impact how you shine. You see, my love, I wonder if you recognize that this truly is your time to shine. Thank you, everyone, so much for listening, staying on to listen. Thank you, Kenyora, for inviting me. Like I said, I know sometimes it's very hard to think positive and to be inspirational, but the fact that we had over 1,000 people on this call means that there is community in this space and that we can all make a change. So I just want to leave you with that.
Thank you so much, Cheyenne, for being with us. Thank you for your time. Thank you for your light. And again, I just want to thank everyone for joining us again today. Please stay safe. Please stay healthy and be well during this time. Please stay tuned for more. There's a lot more that we will be sharing with you in the upcoming weeks. Our fight for survivors continues. Have a great Friday and a great weekend. Be blessed. Bye.